Maryland exam. 51 to 101 questions. Part 2. Question 51. When do real estate salesperson's licenses expire in Maryland? 1. April 30th of every odd-numbered year. 2. June 30th of every even-numbered year. 3. 2 years from the date of issuance. 4. From 16 to 24 months after issuance as stated on the license. Answer. 3. Real estate salesperson's licenses expire in Maryland 2 years from date of issuance or renewal. Question 52. To renew a license in Maryland, a salesperson must pay 1. $20 to the guarantee fund. 2. $65. 3. $95, which includes $20 to the guarantee fund. 4. None of these. Answer. 4. A salesperson pays a guarantee fund assessment upon initial issuance of a license, not a renewal. A salesperson's license renewal fee is currently $45. Question 53. A licensee allows his or her license to expire. How long after expiration may the licensee apply for reinstatement? 1. There is no grace period, the licensee must retake the state exam. 2. Up to 3 years. 3. No more than 365 days. 4. 1 year from the last June 23rd. Answer. 2. The licensee may apply for reinstatement up to years after expiration of his or her license but must also meet the other renewal requirements such as submission of past due renewal fees, evidence of broker affiliation, completion of any delinquent continuing education credits, and payment of a reinstatement fee as set in statute or as established by regulation by the Commission after July L. 2007. It is currently $100. Question 54. What is required for the first renewal of a salesperson's license? 1. 15 hours of continuing education and a renewal fee set by statute or by Commission regulation. 2. 10 hours of continuing education and the appropriate fee. 3. 15 hours of continuing education and $65. 4. 6 hours of continuing education, all of which must be legislative update and the appropriate fee. Answer. 1. At first renewal a salesperson has only 2 years of license history. Therefore he or she is required to complete 15 clock hours of continuing education for renewal and to pay a renewal fee. Question 55. How many hours of continuing education must a licensee who performs any acts of residential brokerage and has been licensed for 10 years or more complete for renewal of his or her license before October 1, 2008? 1. 15 hours of continuing education is required for all licensees. 2. 10 hours of continuing education. 3. 1.5 hours of legislative update and 1.5 hours of fair housing and 3 hours or real estate ethics. 4. 10 hours, 6 of which must be of legislative update. Answer. 3. For license renewal until October 1, 2008, a licensee whose brokerage activities include residential transactions and who has been licensed for 10 or more years must have 9 hours of continuing education, 3 hours of legislative update, 1.5 hours of fair housing, 3 hours of real estate ethics, and at least 1.5 hours of other approved courses. 56. How long may one's real estate license be left on inactive status? 1. There is no inactive status. The license is either active, surrendered by the licensee to the REC, or recalled by the REC for inactivity. 2. A license may be inactive for up to 2 years. 3. A license may be inactive indefinitely as long as the licensee pays the appropriate renewal fee and has the appropriate number of clock hours. 4. A license can be inactive for up to 3 years as long as appropriate renewal fees are paid. Answer. 4. A license may be inactive for up to 3 years as long as the appropriate renewal fee is paid. Clock hours of continuing education are not required for renewal while still on inactive status. However, they must be made up before an inactive license can be reactivated. Question 57. What is required of a licensee with 6 years of experience who activates his or her license after having been inactive through 2 license renewal periods, but still less than 4 years? 1. Complete 30 clock hours of continuing education, 6 of which must be legislative update, 3 fair housing, and 6 real estate ethics, pay $10 reissuance fee, and affiliate with the broker of his or her choice. 2. Complete 15 clock hours of continuing education and pay $10 reissuance fee. 3. Pay $45 reactivation fee and complete 16 hours of legislative update. 4. Pay $45 reactivation fee and $10 transfer fee, and complete 15 clock hours of continuing education. Answer. 1. A licensee who has been licensed less than 10 years must complete 15 clock hours for each renewal period, 30 hours in this case, since the licensee has passed through 2 license renewal anniversaries. The licensee also needs to affiliate with a broker and pay a reissuance fee to transfer from inactive status to affiliation with a broker. Currently that fee is $10. Question 58. A salesperson wants to transfer her license from broker A to broker B, but has not yet done so. She shows a prospective buyer one of broker B's listings and goes back to broker B's contract form. Was this proper procedure for a transfer of license? 1. Yes, because the salesperson used broker B's contract. 2. No, because the salesperson did not get a release from her current broker A. 3. No, because the salesperson did not have broker A's release or broker B's signature for affiliation, nor pay the fee for transfer, nor submit the proper forms and payment to the commission. 4. No, because the salesperson should have transferred before she showed broker B's listing. Answer. 3. To transfer a licensee must obtain a release from his or her current broker, the signature of the new broker, surrender his or her pocket and wall license, pay $10, and submit the above to the commission. A licensee may not use forms of a broker with whom he or she is not yet affiliated. Question 59. A real salesperson who lives in and is licensed in Pennsylvania, not too far from Hagerstown, Maryland, wants to sell real estate in both states. For this person to obtain a standard license in Maryland, she must 1. First make sure her license in Pennsylvania is current and then get the Maryland license. 2. Claim and pay Maryland income tax on all Maryland sales. 3. Affiliate with a broker licensed in Maryland, complete all the other regular requirements for Maryland non-resident licensure, and sign an irrevocable consent. 4. Affiliate with a Maryland broker who has an office in both Maryland and Pennsylvania. Answer. 3. A non-resident may obtain a Maryland standard license and affiliate with a Maryland licensed broker. The person must sign an irrevocable consent and meet all the other usual requirements, pre-license education and salesperson licensing exam, for licensure. Question 60. In Maryland, an unlicensed real estate assistant may perform all of the following activities except 1. Compute commission checks. 2. Assemble legal documents required for a closing. 3. Explain simple contract documents to prospective buyers. 4. Prepare and distribute flyers and promotional materials under the supervision of the broker. Answer. 3. Only may explain any part of a contract. Question 61. In Maryland, personal assistants who work for affiliates of a Maryland broker. 1. Must be licensed. 2. May insert factual information into form contracts under the employing broker's supervision and approval. 3. May independently host open houses and home show booths. 4. Must be unlicensed individuals, licensees must be either salespeople or associate brokers. Answer. 2. Work of a secretarial nature does not require licensing when done under the supervision of the broker. Personal assistants do not have to be licensed, but then they cannot show homes or negotiate or explain contracts. Question 62. A man will be retiring in about 15 months. He has completed the basic real estate course for licensure and has passed the state exam. He wants to hold off getting his license until approximately 6 months before retirement. Can he hold off getting his license that long? 1. No, he must obtain his license within 6 months. 2. Yes, a licensee can delay licensure for up to 18 months after passing the basic real estate course. 3. No, the licensee must obtain a license within 30 days, but could put his license on inactive status for up to 4 years. 4. Yes, a licensee has up to 1 year to activate his or her license before he or she would have to retake the state exam. Answer. 4. A licensee must apply for licensure within 1 year of passing the state licensing exam or be subject to re-examination. Question 63. Which of the following is one of the requirements for obtaining a broker's license? 1. Affiliate with the broker of his or her choice. 2. Be licensed for at least 2 years. 3. Pass the broker's exam. 4. Complete 90 hours of additional REC-approved broker courses. Answer. 3. A licensee must be at least 18 years old, be of good reputation and character, complete the 135-hour REC-approved broker's course, have been licensed for 3 years, and pass the broker's exam. Upon completion, the licensee would be the broker and therefore, would not be required to affiliate with another broker. Question 64. A farmer purchased 640 acres of land 8 years ago and wants to subdivide half of it into 3-acre lots and sell them all to a developer this year. Is the farmer required to get a license or to use a licensed broker? 1. Yes, because he has not owned the land for 10 years or more and he will be selling more than the permissible 6 unimproved lots in a calendar year. 2. No, because he owns 640 acres for over 5 years. 3. No, because he is only selling half of the section or 320 acres. 4. Yes, because he has not improved any of the lots. Answer. 1. The farmer must obtain a license because he has not owned the land for 10 years or more and he wishes to sell more than 6 unimproved lots in a single calendar year. Question 65. A licensee works for Broker A in the mountains of western Maryland. The licensee also has a summer house in Ocean City, Maryland, where he lives from May until the end of September. The licensee wants to also sell real estate for Broker B while in Ocean City, because Broker A does not have an office there. In this situation, the licensee 1. May affiliate with both brokers simultaneously if they are both notified in writing by the licensee and each broker completes a commitment to allow the licensee to affiliate with him or her. 2. May not affiliate with 2 different brokers simultaneously under any circumstances. 3. Must declare one broker his primary broker for record keeping, but may otherwise be licensed by 2 brokers. 4. May only be licensed in the area of the broker that is his primary residence, usually considered to be where a citizen votes. Answer. 1. A licensee may be licensed under 2 brokers if both are informed in writing and each submits a commitment to allow the licensee to affiliate with his or her firm. 2 licenses are issued and 2 fees must be paid. Question 66. In order for a licensed salesperson or associate broker to sell Maryland real estate, the licensee must 1. Receive their license from the Department of Labor. 2. Be affiliated with a real estate broker licensed by Maryland. 3. Provide brokerage service only in the name of their associate real estate broker. 4. Join the Maryland Association of Realtors. Answer. 2. Licensees must affiliate with a Maryland licensed real estate broker before providing any brokerage services related to Maryland real estate. Question 67. In Maryland, an unlicensed personal assistant may not do which of the following? 1. Answer the telephone and forward calls to a license. 2. Assemble documents for closing. 3. Prepare promotional materials or ads as he or she sees fit. 4. Compute commission checks. Answer. 3. An unlicensed personal assistant may not prepare promotional materials without supervision. Promotional materials prepared by an unlicensed assistant are subject to the approval of the licensee for whom he or she works. The unlicensed assistant may answer the phone, forward calls to a licensee, assemble documents for closing, compute commission, and other general work of a secretarial nature. Question 68. All of the following would be grounds for possible revocation of a broker's license except 1. Being convicted of a felony. 2. Advertising in a newspaper that he or she is a member of the Maryland Association of Real Estate Professionals, when in fact, he or she is not. 3. Depositing escrow money into his or her personal checking account. 4. Agreeing with a seller to accept a listing for more than the broker's minimum commission rate. Answer. 4. Commission rates are always negotiable between the seller and the broker, so accepting a higher rate is perfectly legal. The Real Estate Commission may revoke a license if the licensee has been convicted of a felony, false advertising, or commingling of funds. Question 69. The Real Estate Commission has the power to revoke a salesperson's license if the salesperson 1. Shows a property listed with a broker with whom the salesperson is not affiliated. 2. Attempts to represent a buyer. 3. Enters into an exclusive listing contract with the seller on behalf of the broker's firm. 4. Deposits a buyer's earnest money into his or her own bank account. Answer. 4. Salespersons are not authorized to have brokerage trust accounts. No licensees may place funds of others entrusted to their care into their own personal accounts. A salesperson may show and co-op with other brokers, represent the buyers, and enter into exclusive right to sell listings on behalf of their brokers. Question 70. A broker may have his or her license suspended or revoked for all of the following actions except 1. Failing to provide reasonable and adequate supervision over affiliates. 2. Depositing earnest money into the firm's escrow account. 3. Helping another person cheat on the licensing examination. 4. Displaying a for sale sign on a property without the owner's consent. Answer. 2. Depositing earnest money into the firm's escrow account is proper procedure. Failing to provide reasonable and adequate supervision over affiliates, helping someone cheat on the real estate exam, and putting up a for sale sign without the owner's permission are all subject to disciplinary action. Question 71. For which of the following acts must the Real Estate Commission suspend a licensee's license? 1. Not advertising a listing every weekend in the local paper. 2. Causing a payment to be made from the guarantee fund. 3. Suggesting a listing price to a seller. 4. Not taking a listing because the seller wants to price it so high, that in the licensee's opinion, it will never sell. Answer. 2. If the Commission orders payment by the guarantee fund of a claim based on an act or omission for which a licensee is responsible, the Commission shall immediately suspend the license of the licensee. Question 72. According to Maryland real estate regulations, a licensee may have his or her license suspended or revoked and be fined as much as $5,000 for failing to maintain copies of all the following except an 1. Listing contract to sell or rent real property. 2. Contract of sale. 3. Auto lease agreement when the auto is used only for business purposes. 4. Real property lease agreement. Answer. 3. A real estate licensee is not required to keep copies of personal transactions. Maintaining brokerage transaction records is required under Business Occupations and Professions Article Title 17 Section 322 of the Annotated Code of Maryland. Question 73. Which of the following actions is legal and not a violation of license law? 1. Encouraging a seller to reject an offer because the prospective buyer is a Methodist. 2. Placing a for sale sign in front of a house after asking the seller's permission and receiving written permission to go ahead. 3. Advertising that individuals who attend a promotional presentation will receive a prize without mentioning that they will also have to take a day trip to a new subdivision site. 4. Accepting a listing where the seller wants $65,000 and the salesperson can have whatever he or she can get over that amount. Answer. 2. If the seller gives permission for a for sale sign on the property, the licensee is wise to place one. A licensee is subject to disciplinary action for suggesting that a seller refuse an offer based on religious grounds, accepting a net listing, or for incorrect advertising. Question 74. If a broker submits documents to a lender indicating that the sales price on a property is an amount above its actual sales price, the 1. Broker has done nothing wrong as long as the appraisal substantiates this price. 2. Broker may have his or her license suspended, revoked, and/or be fined not more than $5,000. 3. Broker can lose his or her license but not be fined and imprisoned. 4. Buyer can properly receive a higher mortgage amount. Answer. 2. It is illegal for a licensee to misrepresent the sales price of a property. Question 75. A person is convicted in a court of law of providing brokerage services without a license. This person could receive a penalty or penalties from the court of 1. $2,000. 2. $2,000 and up to 1 year in jail. 3. $2,500. 4. $5,000 and up to 1 year in jail. Answer. 4. The court could penalize unlicensed individuals who provide brokerage services with a fine as much as $5,000 and up to 1 year imprisonment. Question 76. If a broker submits documents to a lender indicating that the sales price on a property is an amount above its actual sales price, the 1. Broker has done nothing wrong as long as the appraisal substantiates this price. 2. Broker may have his or her license suspended, revoked, and/or be fined not more than $5,000. 3. Broker can lose his or her license but not be fined and imprisoned. 4. Buyer can properly receive a higher mortgage amount. Answer. 2. Affiliates may hold reciprocal licenses under a broker who has either a regular or a reciprocal Maryland broker license. All the other statements are true. Question 77. A real estate company has entered into agency agreements with both a seller and a buyer. The buyer is interested in making an offer on the seller's property. Can this occur? 1. No, because the real estate company would then be a dual agent. 2. Yes, as long as written agency agreements have been entered into with both parties. 3. Yes, if the seller has agreed to pay the commission. 4. Yes, if the buyer and seller both give their consent to dual agency and the company broker appoints 2 intracompany agents. Answer. 4. Both parties must have a signed written agency agreement and consent to dual agency. The company broker must also appoint 2 intracompany agents, other than the broker, one to act on behalf of the buyer and one to act on behalf of the seller. Compensation or commission does not determine agency. Question 78. A seller's listing agreement has expired, and the seller lists with a different brokerage firm. Jim, the original listing agent, now has a buyer customer interested in the seller's property. Jim 1. Is a dual agent. 2. Cannot disclose to the buyer offers received on the seller's property while it was listed with him. 3. Cannot disclose to the buyer information about the physical condition of the property. 4. Cannot represent the buyer. Answer. 2. While the original agent no longer has an agency relationship with the seller, any confidential information gained during the listing must remain confidential. Agents must always disclose information about the physical condition of the property. Question 79. A buyer contacts a real estate office and indicates an interest in purchasing a home in the area. The buyer does not want buyer brokerage representation. A salesperson from the real estate office may do all of the following except 1. Provide the buyer with information on properties for sale in the area. 2. Give the buyer information on mortgage interest rates and terms. 3. Reveal the seller's urgent need to move. 4. Provide the buyer with a dual agency consent form. Answer. 3. The agent may not disclose confidential information about the seller, whom the agent represents. The buyer is a customer, having declined representation. The agent can provide information on properties for sale in the area and give out mortgage interest rates. The buyer has no use for a dual agency consent form if he or she continues to refuse representation. Question 80. A Maryland broker may represent both the buyer and seller if 1. The broker belongs to a real estate board or association. 2. The buyer and the seller are related by blood or marriage. 3. Both parties give their informed consent for dual agency in writing and are each provided with the assistance of an intracompany agent. 4. Both parties are represented by attorneys. Answer. 3. Both parties or principals must give their informed consent for dual agency in writing. The broker also must provide 2 intracompany agents, one to represent the buyer and one to represent the seller. Question 81. When a salesperson, in the course of his or her first appointment with customer buyers, is asked to show a property listed with the salesperson's company, the salesperson 1. Must tell the buyers that they must first enter into a buyer representation agreement with another licensee. 2. Should give the buyer the agency disclosure form. 3. Must inform the buyers, either orally or in writing, that the salesperson represents the seller's interests. 4. May show the buyers the property without making any disclosures about the salesperson's relationship with the seller. Answer. 2. The agent's relationship to the seller must be disclosed to the buyer no later than the first face-to-face appointment. This disclosure must be in writing and be on the form established by the Real Estate Commission. Understand whom agents represent. Question 82. The prospective buyers have been to several open houses today. They walk into your office and say they want to write an offer on a home listed by another brokerage. Which of the following is true regarding presumed buyer brokerage? 1. The buyers would need to fully appoint you as their buyer agent and sign the appropriate documents. 2. Presumed buyer brokerage ends when the buyer wants to write a contract. 3. Presumed buyer brokerage ends only when the buyer wants to see a property in your company. 4. The agent should decline buyer agency and work as a co-op agent. Answer. 2. One of the 3 ways presumed buyer brokerage is terminated when a buyer wants to write a contract. Question 83. A real estate licensee has signed a brokerage agreement with a person who is looking for an apartment to rent. The licensee does not charge a fee to prospective tenants, rather, the licensee receives a commission from landlords. The licensee tells a landlord that the prospective tenant could probably pay a somewhat higher rent than the landlord is asking. Which of the following statements is true? 1. The licensee owes the statutory agency duties to the landlord who pays the commission. 2. The licensee's disclosure to the landlord was appropriate under these circumstances. 3. The licensee's disclosure violated the statutory duties owed to the prospective tenant. 4. Because the licensee is not charging a fee to the prospective tenant, the licensee has not violated Maryland's agency statute. Answer. 3. The licensee owes a duty of confidentiality to the prospective tenant who hired the licensee. The disclosure was a violation of this fiduciary duty and of the licensing laws. Representation is determined by who does the hiring, not by who pays the fee. Question 84. A buyer is interested in being shown a house listed with XYZ Realty but does not wish to enter an agency relationship. A salesperson from LMN Realty can show the buyer the house if 1. XYZ Realty has the seller's written consent to sub-agency and the buyer is given an agency disclosure notice stating that LMN Realty represents the seller. 2. XYZ Realty obtains LMN Realty's consent to sub-agency and the buyer is given an agency disclosure notice stating the XYZ Realty represents the seller. 3. The buyer orally agrees to buyer agency. 4. The LMN salesperson may not show the XYZ Realty's property in this situation. Answer. 1. If the owner has authorized the listing firm, XYZ, to extend sub-agency and the salesperson from LMN has given the customer the required agency disclosure form, that salesperson may show the property. LMN is not in a position to consent to sub-agency, LMN needs someone else to consent to their acting as sub-agents. Question 85. In Maryland, a broker formally represents 1. The one who signs a written representation agreement. 2. The seller, since the seller is the common source of payment, even for a buyer broker. 3. The one who agrees to pay them. 4. All of the above. Answer. 1. Representation, except for presumed buyer representation, is determined by a signed written agreement between the client and the agent/broker and not by payment or promise of payment of a fee. Question 86. A salesperson is showing a buyer real estate listed by another brokerage company. The buyer has been presented with the agency disclosure form and also has refused buyer agency. Under these circumstances, the salesperson represents 1. Both buyer and seller. 2. The buyer. 3. The seller. 4. Neither buyer nor seller. Answer. 3. Because buyer brokerage has been refused and the listing is another company's, the salesperson is a cooperating agent and represents the seller. Question 87. A buyer walks into a real estate company and says to an agent on duty, "I want to see one of your listings." Which of the following is true regarding presumed buyer brokerage? 1. Presumed buyer brokerage begins the moment a member of the public asks for help, so the agent represents the buyer. 2. The agent is a dual agent. 3. The agent could be an intracompany agent in this case. 4. The agent represents the seller. Answer. 4. One of the ways presumed buyer brokerage is terminated is when a prospective buyer wants to be shown a property listed with the licensee's company. Thus, this agent represents the seller. Question 88. All of the following are true regarding confidentiality except that information gained. 1. While representing the seller must not be disclosed in a way that is adverse to the interests of the seller. 2. During presumed buyer agency must not be disclosed in a way that is adverse to the interests of the buyer. 3. During presumed buyer agency may be disclosed if the buyer later rejects buyer representation. 4. During representation must be held confidential even after the transaction has settled. Answer. 3. Information gained during any period of representation, whether it be seller, buyer, or presumed buyer representation, must be held in confidence even after the end of the representation period. Question 89. When broker George sells his client a property offered by listing broker Martha, which one of the following statements is true? 1. George is the subagent of Martha. 2. George is acting as a cooperating agent. 3. George is the agent of the purchaser. 4. George is the subagent of the owner-seller. Answer. 3. Selling broker George is the agent of his own client, the purchaser. Listing broker Martha is the agent of her client, the owner-seller. There is no sub-agency in this situation since each broker represents his/her own client against the client of the other broker. Therefore, there is no cooperating agent, because Maryland law uses that term to identify a sub-agent, not a broker representing a buyer. Question 90. In which of the following situations must a seller give a buyer a property disclosure and disclaimer statement? 1. Initial sale of single-family residential real property. 2. Transfer of single-family residential real property to be converted by the buyer into use other than residential or be demolished. 3. Transfer by a fiduciary in the course of the administration of a decedent's estate, guardianship, or conservators of trust. 4. Seller selling his own house in which he is currently living, without the representation of an agent. Answer. 4. Maryland law requires sellers of 1 to 4 residential units to give a property disclosure and disclaimer statement whether or not an agent is involved. Question 91. If purchasers receive a property disclosure or disclaimer statement after they enter into a contract, the purchaser may rescind the contract. 1. Up to 5 days after receiving the form. 2. Up to 10 days after receiving the form. 3. Up to 20 days after receiving the form. 4. Only if there is an inaccuracy in the form. Answer. 1. If the purchaser does not receive the property disclosure or disclaimer statement before entering a sales contract, the purchaser retains the right to rescind the contract within 5 days after receiving the form if the buyer has not already made formal loan application. Question 92. A seller has no knowledge of any plumbing system problems on the property he is selling. In actuality, however, the pipes have seriously corroded and will soon need replacement. In the seller's property condition disclosure statement, when responding to whether the plumbing system is in operating condition, the seller should respond. 1. Yes. 2. No. 3. Unknown. 4. The seller would not be required to respond to this question. Answer. 1. The seller would say yes, since the seller has no knowledge of the pipe's poor condition. Question 93. In Maryland, when a broker is listing a home and the seller is the owner in residence, which of the following statements is true regarding the property condition disclosure and disclaimer form? 1. The disclosures are optional and the seller may avoid liability by refusing to make any disclosures about the condition of the property. 2. The agent should let the seller fill out the form in whatever manner the seller desires, even if the agent knows some answers are untruthful. 3. The agent should fill out the form based on his or her own thorough inspection of the house. 4. A seller is required to provide prospective buyers the disclosure and disclaimer form at or before buyer submission of the offer to purchase. Answer. 4. Maryland law requires the sellers to furnish to buyers a property condition disclosure and disclaimer statement for the sale of a structure containing 4 or fewer single-family units. Even if the sellers choose to disclaim rather than disclose, they are still required by law to voluntarily disclose to the other party all material facts about the condition of the property. Question 94. 5 years ago, there was a highly publicized brutal murder in the front yard of a home now for sale. How does Maryland law view this matter? 1. The murder, no matter how brutal, is not a material fact in the sale or purchase of a home and the licensee is not required to disclose the murder. 2. The licensee would have to respond to a direct question about crime in proximity to the house. 3. The licensee must disclose the murder to any purchaser. 4. The licensee may, at his or her option, disclose the murder to any purchaser. Answer. 1. Title 17 to 322.1 of the Business, Occupations, and Professionals article of the Annotated Code of Maryland states that it is not a material fact relating to property offered for sale or lease that a homicide, suicide, natural death, or felony occurred on the property. The prospective buyer should be referred to local police authorities if the buyer asks about crime in the area. Question 95. A broker took a listing for a small office building. Because the property is in excellent condition and produces a good, steady income, the listing broker's salesperson has decided to purchase it as an investment. If the broker's salesperson wishes to buy this property, the salesperson must 1. Resign as the broker's agent and make an offer after the owner has retained another broker. 2. Have some third party purchase the property on the salesperson's behalf so that the owner does not learn the true identity of the purchaser. 3. Obtain permission from the Maryland Real Estate Commission. 4. Inform the owner that the salesperson is a licensee with the listing company before making an offer. Answer. 4. When purchasing for themselves, salespersons, as well as associate brokers and brokers, are always required to make known to a seller that they are licensees. In this case, the salesperson should also point out that he or she is affiliated with the company that holds the listing. Then written contract offer must also show that the offerer is a Maryland real estate licensee. A licensee acting as principal is not required to resign, use a third party, or obtain permission from the Maryland Real Estate Commission. Question 96. A real estate licensee must give the understanding whom real estate agents represent disclosure form to prospective purchasers. 1. Not later than their first scheduled in-person meeting. 2. Before the buyers are shown any properties. 3. At any open house the licensee holds. 4. Before any offer to purchase is prepared by the licensee. Answer. 1. Licensees are required to make agency disclosure not later than the first scheduled face-to-face meeting. Question 97. A licensed salesperson obtains a listing. Several days later, the salesperson keeps a first appointment with an unrepresented prospective buyer at that property and tells her, "I am the listing agent for this property, and so I'm very familiar with it." Under these circumstances, the salesperson 1. Has failed so far to properly disclose his or her agency relationship. 2. Has properly disclosed his or her agency relationship with the seller. 3. Is in violation of Maryland regulations because the listing belongs to the broker. 4. Has created a dual agency, which is a violation of Maryland regulations. Answer. 1. The buyer does not understand what the buyer's relationship or the seller's relationship is to the salesperson. Agency representation is not about the property, rather, it is about the duties and obligations to clients and customers. In this instance, a salesperson is required to give an unrepresented prospective buyer an agency disclosure notice at the first face-to-face meeting with the buyer. This notice must indicate that the licensee is acting as the agent of the seller for this property. Note, when a salesperson shows a prospect, a property listed with the salesperson's firm, any presumed buyer representation ends. Question 98. A real estate broker representing a seller knows that the property has a cracked foundation and that its former owner committed suicide in the kitchen. The broker must disclose 1. Both facts. 2. The suicide, but not the foundation. 3. The cracked foundation, but not the suicide. 4. Neither fact. Answer. 3. The licensee must disclose the cracked foundation but is not required to disclose the suicide. Question 99. Broker L has entered a listing agreement with a seller. Broker B, who has just begun working with a buyer, learns of the property through the MLS. Broker B's buyer has received and signed an agency disclosure form but nothing else. At this point, Broker B is representing the 1. Seller as a subagent. 2. Buyer as an agent. 3. Buyer as a subagent. 4. Buyer as presumed buyer agent. Answer. 1. Seller as a subagent. Question 100. Which of these disclosure forms is needed in every residential sales transaction involving a real estate licensee? 1. A lead-based paint disclosure for a house built in 1979. 2. An agency disclosure form. 3. A high-tension electrical power lines disclosure. 4. An airport and heliport locations disclosure. Answer. 2. Maryland requires the use of the agency disclosure form in every residential real estate transaction involving a real estate licensee. A lead-based paint disclosure is a federal requirement for the sale of any residential property built prior to the target year of 1978. Neither Maryland nor federal law requires disclosure regarding high-tension power lines or airport locations. Question 101. Owners of affected residential rental properties built before 1978 are required to register those properties with the Maryland Department of the Environment. 1. One time and pay $150 for each unit. 2. And pay an annual renewal fee of $15 per unit. 3. Each year and pay a one-time fee of $100 per unit. 4. Every other year and pay a one-time fee of $50 per unit. Answer. 2. Owners must first register properties built before 1978 and containing at least one rental unit and then pay an annual renewal fee of $35 per unit. Thank you for watching.